Hi, I'm Linda Gray, owner-broker of Coldwell Banker Coast to Coast Properties in Playas del Coco, Guanacaste. On behalf of our sales team who are participating in this class, we want to thank you, Andres Montejo, not only as an attorney and notary, but as a senior professor at the University of Costa Rica Law School. We all thank you.
Okay, now you have a lot of questions. Who wants to begin? You, Nuria?
First, when you were talking about types of properties and the agricultural and making it into a gated community, first I had a question on rezoning. So if something is zoned today being agricultural land, can that owner go and make a petition to the county and to say, I want it to be residential lots and I want it to make a residential community, or I want it to make a commercial property? Are there some limitations on that? I mean, in the United States, there's a process, it's lengthy, and then you've got to pay some back taxes on that. What is it like in Costa Rica?
Okay. Zoning is one thing, and the other one is how we got into an agricultural parcel, and now we need to put this together. You can have an area which is, as zoning is, it's agricultural and could be changed to residential or a combination agricultural residential. Usually agricultural comes with residential because whoever has a land for agriculture will have a house there, so it will be included. The first answer is yes, zoning is all the time in a process of changing. Of course, otherwise we'll have only small towns, but towns are growing and becomes a city, and so they are in the process of changing. One thing is the zoning, which could be changed or partially changed only by the city hall, and the other one is the regulatory plan, in which all cities should have them for the whole county, and which have a longer process because you need to have complete studies and plans, and some other institutions are involved, and there is a process in which the communities also call for their opinions, etc., for the regulatory plan. Now, the problem that an agricultural lot or lots will face in order to turn into more urbanization is how those lots were created. Because if they were created under an easement that eventually could become a public road, in order to become a public road, needs to have a specific width, for example, no less than 11 meters width or 14 meters width. So the problem is that not in all cases were done that way. So how are you going to do it now when you have private land in the sites? You need to first, you need to take land from the owners. But second, could we do it? I mean, physically speaking, going up into the mountain, there is space to do it. Mm-hmm. And also, when you create an urbanization as well as a condominium, both, you need specific things that the law asks for: the width of the roads, sidewalks, playgrounds. So in order to change a community that is already under agricultural easement into an urbanization or a condominium is quite difficult because of that. Now, if it is done, then we do not need 5,000 square meter lots. Then we can create more lots out of that. But the answer is yes, could be done. Difficult, very difficult.
Just following on that, so if somebody was to create urbanization from that agricultural land, and I'm not sure if I'm following, but you said that there's a difficulty about enforcing CC&Rs and also collecting the maintenance in those type of communities. So is there a solution to that, or something the owner should have done ahead of time?
The way of doing it is under a condominium. And I'm going to give it with an example, obviously without saying names, of an actual client that I have. He has a big property. He has the option in that big property to create just an easement that actually part of the road is there. Create big lots, 5,000 square meters, and sell. No electricity is needed, no specific roads or kind of roads, no water. I mean, he could just sell the land. Could he close that the main entrance? Yes, because the easement is private. But there is no law that says that if he wants to ask for a fee for maintenance, that he could do it. There is no law that says, okay, these are the conditions in which you are buying, and the houses should be this way, or you cannot build this, or you cannot have X animal. There are no bylaws, there are no CC&Rs at all. So some of them will create CC&Rs. And actually the first buyer could sign an agreement saying, I agree on this. But if he sells to someone else, then this someone else does not need to agree on this because there was a private contract. So the best way, and I have recommended this client of mine, is just create a condominium. But the problem of creating a condominium is that you will need to comply with a specific law, saying with playgrounds, sidewalks, what an urbanization asks for, and you can add a gate, and you can add a guard, and you can add CC&Rs, and you can add an administrator, and all that is enforceable. And if you do not pay, I could foreclose. Big difference. But there is no, once you have an urbanization, for example, that road becomes public. Public means that it's owned by the government, it's owned by the county. It's public. Anyone could go in and out, in and out. You can, if you gate it, the city could come and take out the gate. It's public. An easement is private, but not enforceable CC&Rs and maintenance. So the best way, condominium. More expensive, more complicated at the beginning.
I had a question regarding, let's say an owner has 2 parcels and he's built a house and eventually he sells the one parcel and, encroaching. So what happens with that legally afterwards if he's too close to the borderline? How do they deal with that with your experience?
Let me see if I'm understanding. You have a parcel, in that parcel, you buy one house.
Yeah, like he's divided it. There's 2 parcels there, the same owner, but he ends up selling one of them. Now his house is too close to the borderline. What happens here legally? Like how do they deal with that?
2, and the house.
Encroach.
But it's different to encroach than just in the line. It's totally different, because if it encroach, okay, we need to go in one way. If it is just here in the main line, it's different. According to the Costa Rican Civil Code, you can build up to here, unless in a normal urbanization lot. It will be very different if it is a condominium. For example, there are condominiums in that says in the bylaws you need to set back 3 meters or 5 meters in the front, 5 meters in the back, and 3 meters in the sides, just to say something. Bylaws. In the normal title property, you are able to build up to here, which is different if you build in the other piece of land, in which you need to go into a lawsuit, and it's another topic.
So you can actually build not just a fence. You're talking about the whole construction right up to the line.
Yes, that's why if you go to main cities in Costa Rica, you will find a lot of properties that are just one touching the other one. And that is according to the civil code that could be done.
Yeah, thanks.
I have a question about the Marítimo Zona Terrestre.
I have a question about the Zona Marítimo Terrestre. It's always been a thing I wonder about. And as per you being a lawyer in Costa Rica, there's people who, like customers that we have, foreigners I'm talking, that they say, well, I don't want to buy there because it's dangerous, and what if it gets taken away by the government, etc. So what are the chances for this every 20 years that I will get the renewal denial or decline in a concession property in Costa Rica? I mean, maybe I'm asking a question that you don't know, but what are the chances, in other words, that in Costa Rica that will change?
Okay, this law was approved in 1977, the last maritime zone law. I've seen cases just when the one that was granted with the concession does not comply with the contract. In other words, I'm the city, I give to Mr. X a property, a piece of land in concession in order to build a house. 20 years, no house there, or even less. 10 years, no house there. Then the city will begin a process, needs to done, an internal process needs to be done. It could end at, even at court in order to take back the concession, because one of the parties means the concessionary, the one that received the concession, have not complied with what he was supposed to do. That is the only case that I've seen. If you get the concession and then you build a house and you're using the house or renting or doing whatever the contract says, the contract between the city and this concessionary, I have not seen any case in which they will take back the concession. Now, does the government has the option to do it? Yes, of course. But if there is no reason for doing, then the government needs to pay you all your improvements and your concession and even damages. So the city is not going to do it if there is no reason for doing it.
Okay. So another question about this: the value on this property, how is it set? The real estate value on this property.
Well, let me put it the other way around. I mean, when we talk about values, we need to talk about values of any kind of property. Any kind of property. What I have called here title, or what I have called here concessions. And let me add also here that concessions are also titled and registered at the public registry. The difference is that it's titled as a concession. Now, how do you value the properties? Well, we have very different kind of values. We have a market value, we have a register value, we have a fiscal value, we have a bank value, and that is something that you, when you're going to purchase land in Costa Rica, you need to learn about, and all realtors and all real estate agents should know and learn. Let me explain a little bit. The concession is registered based on what it's called a canon, which is a kind of tax that is charged by the city according to the law, which up to now goes up to depends on, I was going to talk about taxes, but first depends on the value that they decide that the property will have. How do they decide it? With their own engineers. And it's registered under that value, period. Now, which is the real value? Well, for market purposes, will be probably double or triple of that for marketing purposes. But if you bring a bank appraiser, it will give probably half of the market value. And it also depends on the improvement that the property has and et cetera. Now, even if we go to the title properties, one thing is the amount that has been registered. Let's just think on a house that was, or a piece of property that was registered 30 years ago and hasn't been sold, and no one had make any change. The registered value could be very low. But the fiscal value has been improving because you need to declare your property every 5 years at the city. So you will declare based on the amount that you think that the value, the real value of the house is. And if you do not declare this, then the city will appraise the property and give a value. So there you have what is called the fiscal value for taxes, for tax purposes. Now, if you go to the bank, and the bank is going to appraise the property in order to give a loan, most probably is going to give a value of no more than 70% of the market value. And the loan will be less than that, of course. Okay, and then what is the real market value? And the market value goes like this. Depends on several different issues. So, sorry that I'm answering this way, but there is no specific way to tell you, well, this is the real value of a property that is beachfront. Once more, it's not the same if you have a beachfront property in a town, that if you have a beachfront property far away and still being beachfront property.
Thank you very much.
Thank you. I have a couple of questions, and one thing I'd like you to verify for me. In speaking about the building right on the property line, I understood that there could be no windows on that wall or that, where the construction is on the property line, is that correct?
You're totally correct. The question in that moment was, I could build up to where? You can build up to the line. However, if you want to make any window looking to the other property, if it is in the line, that window could not be less than 3 meters from land going up, right? And you need to do it in such a way that you cannot throw anything to the other property and that you cannot see. This is according to the civil code. Just remember that the civil code was created in 1888. So, I mean, we have more than 100 years, so that's why it was created that way. Now, if you want to make another type of window, then in that case, a setback will be needed of 2 meters at least or more, and then you can make it in a lower place of the house. But only if windows are going to be there. In other words, if I just have a wall, you can build a whole wall.
All the way to the end.
All the way to the end.
Okay, and also, you were talking about the few pieces of property that were titled on the beach. I want to make sure I understand that the first 50 meters cannot have title, even though the rest of the 150 does.
What the King of Spain said centuries ago was that the property was up to where a horse could be standing in the water. So pretty much up to here, right? More or less. Okay?
Oh my God, look at you.
Okay? Pretty much like that. Okay? Now, actually the law says, well, we're going to respect what the king said centuries ago, but up to here. In other words, this area is still, it's public.
And because I understand there have been changes in that high water mark. What happens if the land changes due to tides and erosion? What happens to the construction within that concession?
Well, that's another class. It's totally another class. And I could tell you that as of today, I have one case here in a beach called Hermosa, in which that happens. This was, first, topographers, and you, Alfred, could explain a little bit better, because topographers knows how to do it, but only could be done by what is called the Instituto Geográfico Nacional, even though other topographers know how to do it. And they will measure this from what is called the pleamar ordinaria, which is, technically speaking, varies from the Atlantic to the Pacific, and it's quite complicated to be explained. So it's easier just to say, let's calculate middle tide. From there, it's measured, okay? And we get up to the first 50 meters, okay? In those 50 meters, there will be a sign, okay? That it's called mojon. We call it mojon, or a sign. And from there on, it's 150 meters. Now, what had happened? In several cases, different things had happened. In old times, this mojon was not concrete, which lately has been done with concrete, but it was done with wood. So obviously, will disappear or could be taken out very easy. Okay. Now has been done in concrete, and lately it's done by a satellite. So there is no signs. Just the topographers will.
In Costa Rica?
In Costa Rica. So the topographers will know exactly where the mojon is, and they could measure out from there. Okay? Now, that is one of the things that sometimes complicates. The other one is the tides, the ocean moving, the earthquakes, in which will take a little bit out of the land, or we'll put it deeper. So now I have a problem which hasn't been resolved, and that's why I cannot give a perfect answer, in which, let's say this is the concession, okay, and there was a building here, all right? Everything has changed, have moved, now, the problem is that with the new measures, actually the concession gets up to here. It's like this. So there is a piece here in which the building is there, but it's out of the concession. According to the law, the actual law, that piece of land is owned by the government, so could not be owned privately. The discussion is how does we work this under concession in such a way that, this cannot be given in a concession, because concessions are given only through specific laws, and there is no law that says how to give this in concession. So what the city have been doing is that they have been granting, without saying anything, have been granting that right because the building is there. But if there is no building, then everything will be moved when you need to renew the concession. So the only case that I know is this one, because there is a building. If there is no building, everything will be moved, and your right is going to be granted, of course, but move a little bit, if it is this way or that way. The problem is going inside land, because if it goes inside land, will affect the title property, which could not be affected. So your concession will be reduced.
That was the case in many places here in Copa.
Sarah.
One more question. You were talking about the Papagayo Peninsula, that Plano Regulador is based on the ICT coming down to Playa Hermosa, right? So does that Plano Regulador supersede the one from the city?
There is, in that area, there is no city regulatory plan. It's only this big regulatory plan for the area.
So concessions in Hermosa can...
No, it's up to, it's exactly, just for the specific case, it's up to where Condovac ends. I don't know if you've seen a big sign that says, "Welcome to Papagayo," right over there. So from that sign to where Hermosa is the city of Carrillo. From there up to Cabuyal, it's ICT. Okay, for regulatory plans. Doesn't mean that it's not owned by the cities. Okay, the cities need to approve the constructions and everything as normal. I'm just answering your question in regard to the regulatory plan, which is a different one.
So, but the regulatory plan between the city and the Papagayo, the ICT, cannot vary. Who agrees? How do they get agreement?
For Papagayo area was a regulatory plan approved by the central government. The executive power of Costa Rica means the ICT and the government, the president, for that area. So the city has to do nothing with the regulatory plan, which is very different of getting permits for building or paying bills or taxes. That needs to go through the city hall. But the regulatory plan was approved by ICT.
So concession renewal within that Papagayo plan, who controls that?
ICT.
ICT.
And it's registered through ICT at the public registry.